Kansas laws provide that grandparents may be granted visitation rights with children in a divorce proceeding. The law provides that the court should determine if it is in the best interest of the child to have reasonable visitation when a substantial relationship has been established. To do this, the court's going to have a hearing and take evidence, which may be in the form of tangible things, such as documents, photographs, videos, recordings, or testimony of witnesses. The court will consider whether there is a substantial relationship between the child and the grandparent or grandparents, and then what would be considered to be a reasonable amount of visitation based on that relationship. The court is given much freedom to make these decisions because these relationships between children and grandparents vary widely in today's times. In some situations, grandparents may actually function less as grandparents and more as parents, and the court needs to be able to appropriately gauge those relationships and determine what's best for the child, how to ensure the child receives the best outcome. The central or guiding focus the law gives the court is to do what is best for the child. Now, if you didn't notice, I said the law allows the grandparent visitation in divorce proceedings. Well, what about if the mother and father were never married? Then that's not a divorce, but what we call a paternity proceeding. And the statute that gives grandparents rights only says it applies in divorce proceedings. However, in 2015, the Kansas Court of Appeals said this law cannot be applied only to divorce because it would create a difference in treatment of children born of marriage and those that were born out of marriage, because it violates the equal protection rights of those children. In short, the law saying it applies only in divorce violated the Constitution because it gave different rights to different children based on whether their mom and dad were married when they were born or not. Thankfully, the courts allowed the rights of the children to equal treatment to prevail. And now we definitively have an answer that the rights in the divorce proceedings are the same as the rights in paternity proceedings. So children born to a mother and father that are not married still have a right to see their grandparents, and that means that their grandparents still have a right to see them. Now, the court will still use the same best interest test, but this case made a huge difference to those children that may have otherwise been denied the ability to have relationships with their grandparents. If you are a grandparent and want to be sure your rights to have a relationship with your grandchild are considered, then you should contact us as early in the divorce or child custody proceeding as possible so that we can ensure you are involved in any potential resolution.